legal issues in Georgia, including auto accidents, personal injury cases, and criminal defense law. Here is your host, Attorney Jason Carnell.
All right, folks, welcome back to another episode of my podcast. Again, I'm Attorney Jason Carnell, licensed to practice in the state of Georgia. Almost every legal issue that I take up is going to be related to personal injury cases or criminal defense cases in the state of Georgia. I can't imagine I'm going to do a lot outside that very narrow scope. So if you're tuning in from another state, this might not necessarily be relevant to you, but if you happen to have something going on in the state of Georgia, maybe it is. So today what I'm going to be talking about are property damage cases in car accidents. So specifically, we're dealing with car accidents. Okay, we're not dealing with the personal injury aspect of it. We're dealing with the property damage aspect of it. Okay, and specifically, when the insurance company, for one reason or another, won't pay. Okay, and specifically, when we're talking about someone else's insurance company, not when you're filing a claim with your own. So again, this particular podcast is very narrow. It's car accident cases, specifically dealing with property damage, and when you're trying to get the other person's insurance to pay. That's what we're going to be talking about here today. So as I mentioned before, today we're going to be talking about property damage claims, specifically when dealing with someone else's insurance company when you've been in a car accident. So, like I said earlier, this is specifically when someone hits you and you're dealing with their insurance company. So you're trying to get them to pay for either repairs to your car, replacement of your car, or in some cases, the diminished value of your vehicle. Now, there are a couple of reasons why the insurance company won't pay. So first of all, they may disagree with your valuation of your vehicle. This is very common. People will put aftermarket modifications on their car, new wheels, new tires, things like that, and they believe that this increases the value of the car. Sometimes it does, sometimes it doesn't. Or they may believe that just based on the purchase price of the car, that their vehicle should be worth more than what the insurance company is willing to offer you. So these are the things that you'll see most frequently. Now, on the other hand, another reason why they may not pay is because the insurance company is disputing liability. And this can happen for a couple of reasons. Number one, the most common, is because the police officer actually didn't write anybody a ticket. So even though you told your version of the collision to the officer, the physical evidence at the scene appears to back you up. The other party had a different story. The officer sort of shrugged his shoulders and decided not to write anybody a ticket. Sometimes you'll see this just because the officer feels bad for the at-fault party. Maybe they're doing him a favor. Maybe the person's only 16 or 17 years old and the officer doesn't want to besmudge the person's record, so they don't bother writing a ticket. And this can cause you a lot of problems down the road when their insurance company decides that they're not going to pay you because they're disputing liability. The officer didn't write a ticket. Okay? It can also happen even when the officer does issue a citation to the other person. For whatever reason, either the officer believed or there may be some evidence to suggest that you were also negligent. So perhaps the person who you were involved in the car accident with, they made what you believe was an illegal left turn. They were issued a citation for making an illegal left turn. But the person that you were involved in the accident with told both the officer and their insurance company that you were speeding. All right, that's what's known as contributory negligence. Sure, I'm at fault for the accident or I bear primary responsibility for it, but some liability needs to be placed on you because you were speeding. So in these cases, and I'll just use some nice round numbers for simplicity's sake, let's say that the value of your vehicle is $10,000. So the insurance company may call you and tell you that they're assigning a 20% liability to you because they believe that you were speeding. And so therefore, that means that they only have to pay 80% of the value of your vehicle. And they're offering you $8,000 for your $10,000 car. So what can you do about it? Well, OCGA, and OCGA stands for the Official Code of Georgia, 33-4-7 is a statute specifically focused on third-party property damage claims. So this is when you are making a claim for property damage against someone else's insurance company. There's a completely different statute for when you're making a property damage claim against your own insurance company, and I may cover that in a subsequent episode. But for now, OCGA 33-4-7 is just for a property damage claim against someone else's insurance company. Now, the statute reads that this statute creates an affirmative duty for their insurance company to adjust the loss fairly and promptly. Okay? If they fail to do so, they can be liable for the loss. Okay? Whatever either the value of your vehicle was, the value of the repairs to your vehicle were, or like I said before, the diminished value in diminished value cases. They can also be liable for a bad faith penalty equal to 50% of the loss or $5,000, whichever is greater. Now, this is obvious. Having the two different standards is there for a reason. It's to prevent the other person's insurance company from failing to fairly and promptly adjust the claim in a situation where your car really isn't worth very much. Okay, so that's why the minimum that they're going to have to pay for bad faith penalties is $5,000, even if your car was only worth $2,000. And also reasonable attorney's fees. And this can be calculated based on a percentage of your total recovery. Okay, so if your total recovery is $10,000 and the attorney's fees is 40%, then that would be an additional $4,000. Or it can be based on an hourly basis. So if your contract with your attorney is for $300 an hour and your attorney works 20 hours on the case, then that would obviously be $6,000, and it would be up to your attorney to prove what the attorney's fees for the case were. So how do you do it? Well, first things first, before you go suing people, you have to send a demand. All right? That demand has to be sent to the insurance company, the other person's insurance company, by certified mail return receipt. They also allow you to do it by statutory overnight delivery. I just always do it certified mail with return receipt, the little green card where somebody has to sign it, and then it gets sent back to you in the mail. I always include comparables. I think this is very important for you to do research on the actual value of your vehicle, or in the case of repairs, for you to have gotten more than one estimate to repair your vehicle. Okay? When I talk about comparables for the replacement of your vehicle, it's really important that you find a very, very similar vehicle. And when I say similar, make, model, year, trim level, and mileage. Okay, the hardest thing to find exactly the same is mileage. Okay, but get as close as possible. If you've got a car with 100,000 miles on it and you're using a car with only 50,000 miles on it as a comparable, that's not a comparable vehicle. In that case, you should probably try to get within 5,000 miles, and I would say maybe 10,000 miles at the worst. Send comparables, okay? Same location as well. Don't make these comparable. If you live in Georgia and you're getting a comparable from Seattle, Washington, that's not truly comparable. The fair market value of your vehicle in Seattle is probably different than what it is in Georgia. So try to get them in the local area. Say make, model, year, trim level, and mileage. Okay? Demand an amount certain. Okay, that is reasonably based on those comparables. Obviously, if you have 3 comparables, it's pretty uncommon for them to all be the same price. Err on the side of caution. demand the lowest of the three, or maybe an average of the three. Okay, or you can utilize an appraiser. I've done this before where I've used an expert witness appraiser to provide me with a pre-accident appraisal value of the vehicle based on the same factors that I was just telling you about: make, model, year, trim level, mileage, and in that case condition as well. Any upgrades to the vehicle as well can be given to an appraiser, and they can potentially increase the value of the vehicle because of that. You have to give them 60 days. So when you send this notice, when you send this demand, where you're demanding an amount certain, you have to give them 60 days, and that's from the day they received it. And so what I always do is I wait to get that little green card back in the mail, and I look at the date that it was signed, and I give them 60 days from that date. If they refuse to pay the demand, or they don't pay it within 60 days, you have to sue. Okay, now, depending on the value of your vehicle, you can sue in small claims court, which is magistrate court in the state of Georgia, or you have to sue in state or superior court. Now, when you sue, remember that your lawsuit is actually against the person who hit you. It's not against the insurance company. But even though it's in this particular instance, even though it's against the person who hit you, you still need to serve the insurance company as though they were a defendant in the suit. You must also send a copy of the demand letter and the complaint to the insurance commissioner for the state of Georgia. In the lawsuit, you still have to prove your damages. This is one of the reasons why getting those comparables is so important. You are allowed to testify to the value of your vehicle in front of the judge or the jury. The value of a vehicle is an opinion. All right, but that opinion must still be based on some facts, some research. So if you're going to testify to what the value of your vehicle is or was, you need to be able to sit up on the witness stand and tell the judge or the jury what it's based on. That you conducted research, that you pulled 5 or 6 comparables off AutoTrader, for example, that you took those values, you added them up, you divided by the number of comparables you had, and that's how you came up with this number, for example. Or you can use expert opinion. Again, you can always use an appraiser. You would not be able to use an appraiser's appraisal, the actual piece of paper, as that would be hearsay. Okay, you wouldn't be able to get it into evidence without the appraiser. So you could use the appraiser. You could call him to testify as a witness at trial, and most appraisers actually work pretty cheap as far as that goes. If the jury or judge returns a verdict equal to the amount you demanded or more, you can then address the issue of bad faith damages and attorney's fees. So up until this point, your lawsuit is entirely against the person who hit you. If the judge or jury returns a verdict equal to or greater than the amount that you demanded in your demand letter, then the issue of this insurance company not paying your demand becomes a matter to be addressed in open court. Again, either in front of the judge or the jury. Okay, so the judge or the jury gets to decide whether or not that insurance company's unwillingness to pay your demand within the 60 days was in bad faith. If they find that yes, in fact, it was in bad faith, bam, $5,000 or 50% of the verdict. Okay, and then you get to put on evidence, or your attorney gets to put on evidence of attorney's fees for those damages as well. It's important to remember that until you get the verdict that is equal to or more than your demand, your lawsuit is only against the person who hit you. Okay, the insurance company is not a party in the case until then. Once you get that verdict, then the insurance company, their actions and whether or not they were in bad faith, it's brought into evidence for the judge or jury to rule on. You know, despite the fact that OCGA 33-4-7 can turn a very small fender bender into a very large verdict, it rarely gets used for several reasons. First off, it's most of the time liability is clear, and insurance companies do a decent job of compensating people for property damage. If the insurance company is going to pay, even if they nickel and dime you, we're talking about, maybe a couple $100. And 99 out of 100, maybe 999 out of 1,000 people aren't going to litigate over $300 or $400 or $500 or even $1,000, especially if it means having to wait on your money and go buy another car on your own. At worst, like I said, most folks are just haggling over a couple $100, and they ultimately end up accepting what the insurance company offers. Generally, that makes it just not worth it. It makes it not worth trying to take the case to trial. It's much more common to see OCGA 33-4-7 used in property damage disputes where liability is disputed altogether, okay, or where there is a an apportionment issue, which I spoke on before, where the insurance company is trying to pin a certain percentage of liability on you. So 99 out of 100 times you'll see this. 99 out of 100 times you'll see a lawyer involved in this, or you'll see lawsuits involved in this, when the insurance company is disputing liability, where they're saying, you know what, our guy or our girl was not liable at all, or if they're accepting liability but still they're trying to pin a certain percentage of it on you. Okay? So in conclusion, folks, if you do happen to find yourself in a situation where you've been involved in a car accident with someone else and their insurance company is disputing liability and they're not paying the property damage on your vehicle, either they're not fixing your car or they're not giving you money to replace your car, it may be in your best interest to consult with an attorney and send one of these formal property damage demands to the insurance company to potentially set them up for bad faith. Ultimately, this law is designed to hold their feet to the fire and make them treat the public honestly. Make them honestly adjust property damage claims and accept liability in car accidents where there's clearly no dispute. So if you have any additional questions on this, feel free to give me a call.